Good morning to all across Canada and a very warm good afternoon to those of you joining us based in South Africa or anywhere else in the African continent. I'm Gareth Blaw, President of the Canada-Africa Chamber of Business, and it is my great pleasure to welcome each of you to this webinar today, Understanding the Regulatory Environment for ICT in South Africa. We have an all-star panel joining us, which is fantastic, and of course the leadership of the Government of Canada, based out of Johannesburg and Pretoria, who've been with us today. Very proud to co-host this event with Global Affairs Canada. So thank you very much for your support. We have with us High Commissioner Chris Kuta, followed by our speakers today who are joining us from the law profession. Danny Myberg is Director of the Digital Forensic Lab, and he has an extensive experience in the legal field. And of course, we have Rosalind Lake as well, who's with us. She's a director at Norton Rose Fulbright, South Africa, joining us today from Durban. I want to give a special thank you to the Southern Africa Canada Chamber of Commerce, led by Mike Morgan and his team. We signed a historic MOU under the witness of Minister Mary Ng, Trade Minister for Canada, just last year, and that MOU is a wonderful collaboration for events like these working together. I want to also recognize Nina Dube for her leadership in making this event happen, supported by Michael Shapiro, and of course, under the leadership of Senior Trade Commissioner Marcello DeFranco. It's a privilege to have worked in person and now virtually with each one of you in preparing for events like this one. Well, it's my great pleasure to hand over the floor in a moment to the High Commissioner, Chris Kuta, joining us today from the residence in Pretoria. Chris Kuta is well known in Canada as a distinguished leader and ambassador. He was called to the British Columbia Bar in 1986, and he practiced law before joining the federal government in 1989. In 1990, he joined Global Affairs Canada, serving in Ottawa as an officer in the legal division for Europe, focused on policy planning, and then as director of the Southeast Asia Europe division, again focused on policy planning. He has held numerous posts as a well-distinguished individual in academic matters and has significant experience across the African continent. Just a snapshot of his service includes Kenya, as well as serving as the High Commissioner to Nigeria, work in various Asian countries, including Cambodia and Turkey, and served as ambassador to the European Union at a key time for trade between the EU as well as Canada. It's an absolute pleasure to have you here with us today and to know that you're serving Canada across South Africa and various other countries in Southern Africa. Your Excellency, the floor is yours for the opening keynote remarks.
Thanks very much, Gareth. Good morning, bonjour, bienvenue. I'm pleased that we're able to hold this webinar today, and I hope the technology is working because we're going to be talking about technology. I also wanted to acknowledge that this event's taking place as a result of the close collaboration between the Canada-Africa Chamber of Business and the Southern Africa-Canada Chamber of Business, as well, of course, as the Trade Commissioner Service based here in Johannesburg. I think we all know that South Africa is probably Canada's most significant political and commercial partner in Africa, given its large and its diversified economy, its membership in the G20, leadership role in organizations like the African Union, which has just adopted a continental free trade agreement in which no doubt South Africa will be a key player. What you may not know is that South Africa has recently become an even more important destination for Canadian goods and services. In 2020, two-way merchandise trade between Canada and South Africa, despite COVID, actually increased from $1.3 billion to $2.2 billion, a doubling. Now, that was largely in the South Africans' favor, but I'm sure we'll balance it soon, and it's a very positive sign on the trade side, while investment is also very strong. Again, you're certainly aware that emerging technologies such as the Internet of Things, AI, blockchain, big data analytics are changing global industries. The global shift towards a digital economy increases opportunities for the ICT sector, which is, of course, a key enabler of the digital transition. But you may be less well aware of the fact, and I would say that even of Canadians like myself, that the ICT sector in Canada includes an incredible 43,200 companies, especially SMEs. This dynamic sector is an increasingly important player in Canada's economy, contributing $94 billion to it, or almost 5% of our GDP in 2019, and employing 700,000 people, which are figures I doubt very many Canadians are aware of. On this side of the world, here in South Africa, One key strength of this country in the emerging digital economy clearly lies in its access to market opportunities across this entire vast continent with its rapidly expanding population and wealth. South Africa does share with many other parts of Africa advantages such as a broad youth base, it's a very young population, and a fast-growing middle class, but it has in addition unique technical capabilities. It has natural resources that are going to be needed for the green and the digital transitions, and it has greater access to global value chains. And while COVID-19 has had a massively negative impact on both our economies overall, the ICT sector is well positioned to help us recover and to go beyond. COVID is actually accelerating the change as physical interaction has had to be replaced by digital, something to which we are now all accustomed as we are today, and through the adoption of technology solutions for challenges faced by government, the private sector, the not-for-profit sector, and ranging from education to health to commerce. That said, with such rapid change, we also recognize that clear and predictable regulation is needed to protect people, information, and infrastructure. Moreover, regulation levels the playing field for all the stakeholders in the marketplace. And so it's important for Canadian ICT companies looking to South Africa to understand the regulatory environment that they will face, which is what we'll talk about today. Data is the new oil has become a common refrain. Today's session will enable Canadian companies like yours to better handle data privacy and cybersecurity risks associated with data in South Africa and to prevent data and ICT oil spills. Lastly, I should add that the Trade Commissioner Service Office in Johannesburg and myself, we are here to support Canadian companies in their efforts to do business in this market. So please do not hesitate to reach out to the team with your questions. We have two excellent speakers this afternoon on our program, and so I'm really looking forward to this engaging event. Thanks very much.
Thank you very much, Your Excellency, and a warm welcome to those who've just joined us. We had around 100 registrants for this topic, so very clear interest, and I'm particularly appreciative to all of those who've also been working with us in promoting this particular event. I see Cindy Mzamo has joined us of the Circle of Global Businesswomen, who's worked very closely with us. Thank you so much to each one of you. Well, our first speaker today is going to be touching on a core aspect of the regulatory environment, and that is Rosalind. Rosalind Lake is going to be focused quite extensively on the key provisions of the Protection of Personal Information Act and how this impacts Canadian companies operating or investing into South Africa. Rosalind has extensive experience and is the author of numerous reports and articles that touch on areas around data provision and privacy. She's also been very experienced as a commentator on these matters, particularly focused on international companies coming into the country. She's well recognized as a competition lawyer, recognized for a variety of top publications, including Legal 500 and the who's who of the legal profession. She's got substantive experience in various investigatory issues, including cartels, leniency applications, and her perspective on mergers and opinions across a range of sectors. The bio is on the website. I advise each one of you who'd like to get in touch with Rosalind to please do so. It's an absolute pleasure to have one of the top legal minds with us. Rosalind Lake, the floor is yours.
Thank you. No webinar is complete without someone being on mute when they shouldn't be. So good morning and good evening to all of you. Really delighted to be here. Thank you so much for the opportunity. And really is wonderful to speak to this audience. So this is a big topic with not much time to talk about it. So what I've tried to do is really just give you some highlights of what we're seeing in South Africa, and particularly our new laws that are going to impact on data privacy, e-commerce, and other aspects. So here's our little roadmap. So I'm going to start with the Protection of Personal Information Act because this is really, really a big deal at the moment and very new. I'm going to touch very quickly on the kind of framework for e-commerce and those kind of laws and what we're looking at, what the framework is, and then touch on the digital services taxes, or what they call, software taxes in other jurisdictions, just so you understand where we stand with that. And please do feel free to submit questions as you go along, and we'll do our best to answer any of those. So just to get started now, the Protection of Personal Information Act has actually been on the cards since 2008. It took us a very long time for it to come into force, but it very, very closely models the GDPR, well, the GDPR's predecessor. So a lot of you will be very familiar with the European data privacy law, and I think it's because it put it on the map, because it's the first data privacy laws that we've seen that apply outside of the country or the area that it applies to. So in South Africa, we have the Protection of Personal Information Act. It came into force last year, but there's a 1-year grace period. So there's 12 months for everyone to get their house in order. And then it's going to kick in from the 1st of July 2021. And after that, we're going to have some pretty significant penalties and consequences. So what does it apply to? So it applies when there's processing of personal information where the responsible party is domiciled in South Africa or the processing occurs in South Africa. So don't worry, I'm going to talk about some of these concepts because this terminology might not make sense yet. So it's either it happens by automated means, so anything electronically. I mean, right now, we're conveying our names and it's being recorded. So it is personal information being processed in South Africa and in Canada and anywhere else. Or it uses non-automated means. So, that's Auntie May's filing cabinet downstairs. So regardless, if personal information is recorded somewhere, the Protection of Personal Information Act is going to apply. So what are some key concepts to just understand about how our data privacy laws work? This is a big important difference, I think, from other jurisdictions. It's not something that people are commonly aware of, is that the South African data privacy laws put every bit of responsibility on the responsible party. Now, they would be called the data controller in the GDPR language, and they're really the ones who decide what information they want, what they're going to use it for, where they're going to send it, how they're going to store it. And then when they use someone as their agent to process that information on your behalf. So for example, if you use a payroll administrator, if you use a platform provider, if you use a cloud provider, they're all going to be processing information on your behalf. Now, under our data privacy laws, there's no separate liability for the operator. So it's key, and you'll probably have a lot of requests from South African companies that you deal with to enter into data processing agreements or operator agreements to make sure that that complies with those requirements. So the law actually says we have to have a written agreement that imposes those rights on someone else. So that's just something to bear in mind. You can fulfill both roles also in any transaction. So you need to be fully aware of where you are a responsible party and where you are an operator. So what is personal information? Now, this is something that's pretty significant because as far as we know, there's only one other country in the world that protects personal data of non-natural people, meaning non-humans. So in South Africa, because our constitution protects the privacy of both corporate entities and natural humans and human beings, so our data privacy laws extend the same rights because it's the right to privacy. So now obviously a corporate can't be pregnant, it can't have a health record, but certainly it can have a criminal history, it can have identifying information, it can have private correspondence. Obviously no biometrics or anything like that. But it does mean that, what we see a lot for international companies is they just, you can't simply plug and play your foreign policies, your privacy policies or other things into South Africa without thinking about the extended meaning of personal information, because it does cover a much broader category. And I would just like to flag that there are two categories of personal information that we're always thinking about. The one is sort of just general personal information that's probably less valuable if someone was going to sell it, or less, invasive of someone's privacy. And then we have categories of information and a special personal information. And these require a higher degree of care. So for example, children's information, and a child in South Africa is anyone under 18, none of their personal information can be processed without their parental consent. Similarly, if you want to use someone's biometrics or religious history, health information, you're going to need a higher level of care in the way that you manage that. Because typically we don't rely on consent, because, and as a law firm, we recommend that people don't rely on consent because it can be withdrawn. So better to try and process on other basis when you can. But when you're dealing with something that's potentially going to cause someone more harm, if there's a breach or something, you need to take a slightly more stricter set of controls. Okay, so I've been talking about this term processing. What is it? Firstly, I want to make it very clear that our data privacy laws apply both to the state and to private bodies. So although there are exemptions for state functions like, criminal prosecution, I always think of the example if someone wants to go under, house arrest or be investigated, they can't object to the processing of their fingerprints. So you obviously there are certain things that be in place, but typically almost everything that you do with personal information through its life cycle in your organization, from the minute it kind of comes in or you collect it from a third party, you collect it yourself, it's going to be covered by POPI and the provisions that apply. So really important to have a good handle on what it is that you are doing within your organization. So let's talk about who enforces this act. So POPI is designed, as I said, it follows other models from Europe, but has added a bit of local flavor because we like to do that. So it establishes 8 conditions for the minimum requirements of processing personal information, and I'll touch on those. Those are the common kind of privacy principles we see all over the place. It also establishes an information regulator, and I'll talk about them in a second. It also provides for codes of conduct. Now, this is sector specific. So, certain sectors we've started seeing already want to engage directly with the regulators, so healthcare or financial services, to have specific codes applicable to their sectors. And then obviously one that's really key is it regulates the flow of personal information across borders of the Republic. Now, just because it helps me in understanding this, I like to think of personal information as someone's asset. It's like a car that they take in for a service. You want to know what's going to be done to it. You want to know who's going to work on it. You want to know where it's going to go. If it's going to go across the border, you want to know it's still going to be okay when it gets there on the other side. So there's no prohibition on the transfer of personal information across borders. In the global connected world we live in, information is flowing enormously right around us right now, all over the world. But what it does say is if you are a responsible party, you have to take steps to make sure that when you send that information somewhere else, that it's going to be kept safe. It's going to be protected the same way that it is here. And so this can be dealt with in a number of ways, but it is something to flag that, information that flows across the borders that's personal information is going to have to be protected. We don't yet have any sort of safe zones. The information regulator hasn't issued any safety privacy shield in respect of particular countries, and we're not anticipating that for some time. Then it also, what it does is it introduces even more measures to deal with unsolicited electronic communications. So, spamming laws or direct marketing, we already have a few in place, but this is really taking us into an opt-in environment. And it's also really challenging because our direct marketing has always sat in our consumer laws, and now it's expanded to personal information, which covers jurisdictions as well. So there are a lot of challenges in about, how do you reach out to someone who you want to do business with, who you don't have a previous connection with. So it has changed that a little bit. And also protects people against automated decision making. I mean, increasingly, we're seeing things, for example, that, bots can determine insurance claim outcomes or whether you get a loan or whether you get employed. And so more and more as AI is used to make decisions, it gives data subjects who the information belongs to the rights to be able to say, hey, I want that to be challenged. I want that to be checked by a human, because I'm not okay with it. Okay, so the information regulator, the head of the organization is a lady called Pansy Tlakula. She was previously involved in our elections committees and our credit regulator. The information regulator, as all South African regulators have, has very broad powers. So they're able to conduct search and seizure operations, what we call dawn raids. They can monitor and enforce compliance proactively. They can sue for damages on behalf of a data subject. I think it's important to understand, I know that Canada is increasingly becoming a class action focused environment from my colleagues. In South Africa, we're still fledgling when it comes to class actions, but increasingly we are seeing foreign funders of litigation coming in to assist class actions. So the problem is that people don't really have enough money here or know how to move that, and we don't have a very strong plaintiff's bar. So the fact that the regulator can sue on behalf of data subjects, I think we're going to see an increase in those sorts of actions coming from there. Then because POPI introduces a whole lot of rights for data subjects, you have the right to know who has your information, where they got it from. You have the right to have it destroyed or deleted. We don't have the right to be forgotten in the same way as you do in other jurisdictions. But each organization is required to manage those requests. And when they refuse, they can be appealed to the information regulator. Also, what's happening is we've consolidating our Promotion of Access to Information Act under the Information Regulator as well. So organizations operating in South Africa are just going to have to be really clear on their processes for managing information and making sure, things, we often say to people, if you interview someone for a job and you take down notes about them, that information now belongs to them. So you need to be a lot more careful about what you write down. That's for sure. So what we're seeing the regulator planning to focus on is really not unexpected, because it's the areas where we see the biggest risk from a data breach perspective, and risk to data subjects. So it's really going to be on financial information, health information, data breaches. There's no threshold in South Africa for a notification if there's a breach. So even if only one employee accesses personal information in an unauthorized way, that constitutes a breach that requires a notification. So we're hoping to see some guidelines on that to narrow it, because that's going to mean the regulator is going to be very busy in circumstances that are probably not the most useful for people affected by those things. So then what are the 8 conditions for lawful processing? These are the minimum requirements. Everything is based on the right to privacy. So it's all about, protecting the privacy of the individuals or the organizations involved in the way you manage their information. So something that there's a real shift is that, and I like to use this as my rule of thumb, is that no one should be surprised about what you're doing with their information. So you need to make sure that you are including your privacy notices in the way you describe information, in the way that you engage with people, that no one is surprised that you're processing their information in a particular way. So, that means that, that really goes to the openness factor. Also really important that you don't collect the information for one reason and then use it for something else. If you collect someone's fingerprint to access an office, and then you use it to unlock their iPhone to investigate them, that's going to be further processing that's not authorized. Also, accountability is a big deal. The responsible party carries the can. The responsible party is responsible for anything that happens to that information in their possession. And then security safeguards. This I cannot stress enough. We see organizations, the biggest risk that they face globally at the moment is cyber breaches. And Danny will talk more to what can be done on the criminal side for that. But certainly, I often quote, I think it's an IBM report that says, if for every $1 you spend on data privacy compliance, you save 4 in a data breach. And absolutely, our view is that, data privacy compliance is not about just having a privacy policy or ticking the boxes. It's about your organizational measures. It's about the attitude and the way that you deal with information. And it has to be a board down approach to data privacy, because the fact is we all know that data is the currency of the future, or it is already. And so you want to make sure that you're not going to have any issues with the information that you are using. So yeah, so what happens if you don't comply with POPI? These rules only come into force after the 1st of July this year, but there are some pretty significant consequences. It's important for you to understand that in South Africa, we don't have punitive damages. We don't have treble damages. Typically, the rule is to put someone back in the position they would have been had the harm not occurred. But, certainly because data privacy and privacy, breaches, it's really hard to prove the harm sometimes. And it causes people a lot of pain and suffering that isn't quantifiable. So POPI actually makes specific requirements or specific reference to aggravated damages and damages for loss and pain and suffering. What is key, though, is that it is a form of strict liability. So particularly in a data breach situation, even if you took all the steps and were completely reasonable, if someone is harmed as a result of that, you're going to be liable for that. So really important to be properly insured to make sure that you can manage these situations. Then the regulator, as I said, has a lot of powers. They can issue all sorts of different notices and either refer someone for criminal prosecution. That's usually relates to the management of financial information. If someone, for any criminal prosecution in South Africa, the test is, beyond a reasonable doubt, and you have to have some form of intention or negligence to be found guilty of a criminal offense. And then we have administrative fines. This is actually set quite low at 10 million Rand. Probably just because the act is old and hasn't been updated in this regard. Typically, we see with other regulation that it's a percentage of turnover. So we'll keep an eye on that, see how that is enforced. But there certainly is a lot to comply with. So that could add up pretty quickly, because any non-compliance can trigger a potential penalty. So I just want to quickly touch on the security safeguards, because I do think that it is super important. We just to make sure that you're aware of that, is that if you are processing any personal information, you're obliged to take whatever organizational and technical measures are reasonable in your sector or circumstances against any loss or damage or unauthorized destruction of personal information or unlawful access or processing. So it's a bit broader than we see in other jurisdictions. There's also no threshold for materiality. There's no looking at whether the data breach actually caused harm, and there's no threshold for reporting. There's also no time period, so it just says within a reasonable period. So when people are responding globally to a data incident that affects a whole lot of jurisdictions, you just need to bear that in mind, because for GDPR you only have 72 hours, others you might have 48 hours, and it's always good to try and align that on a global basis. So just raising that again, because data privacy, your risk to the organization is going to be when you lose that data or you don't have it safe. So I would recommend the things for everyone to be thinking about in terms of data privacy issues, which obviously cut across all levels of activity that one might do in South Africa. So you need to be thinking, you know, what personal information do we process in South Africa? What do we get from there? What are we using? So why do we have it? What else do we use it for? How do we secure it? How do we dispose of it? You know, we hear these horror stories about people throwing away documents in clear plastic bags so you can see everyone's information. And most importantly, do data subjects know what we're doing with their personal information? Also, are you transferring personal information to third parties? Are they your operators, or are they also responsible parties? Are they in South Africa? Are they offshore? And these are the questions you really need to think about. The CEO of an organization is the default information officer, and they will have to register with the information regulator. And they have pretty hectic responsibilities in terms of implementing a compliance framework, making sure it's monitored, conducting regular training, and managing all the data subject requests. So there really is quite a lot for parties to get a handle on. And certainly we expect the regulator to be quite thorough in enforcing the Act. They've shown themselves so far to be pretty conservative in their interpretation of the laws. Okay, so that was a whistle-stop tour of the Protection of Personal Information Act. And as I said, I mean, that obviously plays into anything that you're going to be doing in terms of, you know, the big data and the Internet of Things, any AI, anything else that we're dealing with. So just the framework, we don't have any kind of specific e-commerce law at the moment. What we do have is the Electronic Transaction and Communications Act, which specifies standards for sort of safe transacting. It also includes certain disclosures that are required by anyone engaging in e-commerce, and manages e-signatures and so on. That is not an act that has been regularly kind of litigated on or enforced, but certainly is applicable to anyone selling online services or goods. Then we have the Consumer Protection Act, which you'll be pleased to know is mostly drafted by a Canadian. So it does model to a large extent some of the Canadian provisions you see in your consumer laws, and borrowed a little bit from Australia and a little bit of uniquely South African flavor. The Consumer Protection Act obviously is designed for brick and mortar type transactions, but it is equally applicable to online transactions. This is a really extensive bit of legislation. It covers, you know, the minute you start advertising, you know, the actual terms of the transaction, fair contract terms, plain and understandable language, warranties, cooling off periods, all sorts of things. So anyone setting up user terms, developing apps, you know, selling anything online is going to have to make sure that they comply with those provisions when selling to South African consumers. And then lastly, I just want to touch on competition law. The digital economy has been really troubling the competition authorities all over the world. And that's because traditionally we say, you know, the cheaper things are, the better it is for consumers. You know, the more efficient someone is, the better it is for consumers. And now everyone's seeing that what's happened is that digital platforms and you know, companies that we didn't necessarily understand their business model until recently have just been growing bigger and bigger and bigger. And that means that the small businesses are struggling in those markets. But at the same time, it's a great platform for low barriers to entry for startups to get involved. Now, our government is really focused on protecting and encouraging small, medium businesses and those owned by historically disadvantaged individuals. And so we actually are leading the charge, and a lot of competition authorities all over the world are looking to see how our new laws apply, because we have specific laws that protect small, medium, and Black-owned businesses who engage with platforms. so intermediation platforms, the gig economy, and so on. So that's and there's also a market inquiry in the space. So there's a lot of that going on, lots to keep aware of, and we are going to see some real movement and regulation coming out of these market inquiries. It certainly is. Our authorities are looking to proactively regulate the markets, so we're expecting a lot of action in the next while. And then lastly, I know I've probably spoken for too long, this is my last slide, is just to let you know what the position is about tax at the moment. We don't yet have, the so-called income software tax, but certainly it is on the cards. There's a lot of concern about the fact that online entities are able to offer services to South Africans without registering for to pay tax. And that's something that they're really looking into. They want to try and implement some form of income tax for online services. No draft legislation yet, and typically we see it takes about a year from the time that there's draft legislation for anything to change. So no reason to worry about that yet, but of course you can get in touch with us if you need updates. Then there is currently value-added tax, or what you call sales tax, imposed on electronic services, so the Netflixes and the like. Just to ensure that there's fairness among local providers and offshore providers. So you are required to charge VAT and to register for VAT if you're providing electronic services in South Africa. So that's all I have for now. As I say, whistle-stop tour of the ICT regulation. I'm going to stop there. Thank you.
Rosalind, thank you so much for an absolutely fantastic presentation and for so comprehensively addressing the key issues. We really appreciated a lot of good feedback coming in. I know you've got some of the questions already on the Q&A line. For those who have sent questions via email, I'll be getting them over to Rosalind during the course of the program. And also a lot of shout outs, if I may say, to the Trade Commissioner Service from various clients saying thank you so much for your role putting this together. So certainly I think that directed to Marcello, Nina, and Michael, among others. Well, our next speaker today is Danny Myberg, and it's an absolute pleasure to speak with you again, Danny, having been introduced to you a couple of weeks ago. Danny is the Managing Director of CyNRE, the Digital Forensic Lab, and he's joining us to explore some of the top cyber threats facing businesses operating in South Africa, as well as looking at the digital and forensic incidents response processes in curbing these threats when operating. Danny comes to us with extensive experience in digital forensic investigations, data fraud, trend analysis, incident response, as well as e-discovery services and litigation support services. Some of his roles include the fact that he was on the Interpol African Working Group on Cybercrime, that he's represented Africa at the Interpol International Steering Committee. He was chair of the Association of Certified Fraud Examiners from 2011 to 2016, and he also was on the BRICS Expert Working Group on cybersecurity, bringing together all those member states in looking at enhancing their coordination on cybersecurity. Danny, it's an absolute pleasure to have you with us today. Welcome.
Thank you very much, Gareth, and Your Excellency. Thank you very much for the opportunity of addressing you, everybody. Thank you for attending this afternoon. I hope I can impart some knowledge and some information for you. I'm just quickly sharing my screen here. Gareth, is that okay?
Perfect, Danny, thanks.
100%. So thank you very much for this afternoon's opportunity. And being a South African, I'm proud of our country. I think we've got one of the most beautiful nature parts of the world in terms of nature and our big game. And that was the topic that I decided on for this afternoon: cybercrime and cyber threats and big game hunting. And it is actually very relevant for me at this stage because we are engaged with a number of incidents here in South Africa where we are assisting clients, organizations that has been compromised, where we are assisting them to try and stabilize the environment and get the perpetrators out of the environment. So without any further ado, I'm sharing a little bit of our country with you. And I just want to start off. So we're looking there at the game scenery that we've got here in South Africa. And one of the things that we are quite glad about is the fact that if we look at international maps where we're looking at, for example, Kaspersky, where cyber attacks are being monitored, or platforms such as threat maps, the actual fact is that although we perceive that there's a very high level of cybercrime happening in South Africa, in the global scheme of things, it is actually a lot smaller. So we're very fortunate in the sense that it's the perception that we've got from the Kaspersky threat map and Mandian threat maps, for example. You'll see there's a lot more attacks between China and America, the East blocks and the West blocks, and they tend to forget about us here down in South Africa. Unfortunately, that doesn't mean that we're totally safe. The problem that we face is the same problem that everybody's got across the globe, in the sense that the people are typically the weak link in the whole chain. And that's what the perpetrators are also doing, is they're targeting the human weakness in these type of attacks. If we look at the type of attacks that we're seeing here in South Africa that is prominent, the biggest ones, and it's very difficult to say, which ones are the big, but we've got three major type of attacks taking place. Ransomware, basically where they are infiltrating organizations and deploying malware in the environment, encrypting the information and then extorting companies for payments to release the information. In the last couple of months, approximately 6 months, we've seen that the criminals are first stealing the data, then covering their tracks by executing ransomware. So they'll first start off with just asking for ransom payments in cryptocurrency, and thereafter go over to threatening to release or publish the information. Mainly, we see the three types of different attacks: one-day attacks, zero-day attacks, and the all-day attacks. So just to explain to you what those are, your one-day attacks is actually a thing that started not that long ago, where the criminals, whenever a security company releases a patch, they will go and look at that patch and see what else they can attack around that patch. So while you are actually upgrading your systems and patching your environment, the criminals are focusing on how can they exploit that new patch that's coming out. Zero-day exploits is basically where they are using malware and attacks that is not known before. And the all-day ones is basically where they take attack that was useful, they dust it off a little bit, and they combine it with a new attack, and they are very successful with those type of attacks. Secondly, we're looking at the business email compromises, or the BECs. That's basically where the criminals will gain access to an online mail account. Typically, it's an online mail account. We're looking at Gmail, Office 365, those accounts. It's not an attack on your environment. They gain access to your mail account, read through the mails, and if you are involved in transactions or any commercial type of communication, they will climb in between you and the other party. Also referred to as a man-in-the-middle type of attack, or a CEO impersonation. They will then give instructions for payments to be made, or redirect payments to new bank accounts and filter their bank account details into it. The statistics are actually quite staggering. The US Secret Service team here in South Africa has shared with us that their estimate globally is that $300 million are being stolen successfully on a monthly basis because of this attack. The statistics in South Africa is quite high with this in terms of the success rate. So we are seeing 73% of the participants of this study has indicated in South Africa that they fell for the scam and that they made the payment. So a very high success rate of the type of attacks. And your defense with that attack is very low because of the fact that the criminals are actually communicating from the legal mail account of the party to you. Then we're sitting with hacking. Hacking has always been a problem, well-known concept in terms of where breaches are starting. We see that some of the reports that we've seen actually identifies that a hacker is in an environment globally for on average 209 days before his activity is discovered. We've been involved in some of the major cyber incidents in South Africa, and we see that the majority of time it's some of the most simplest things that is the cause of the breach. Here we did an investigation for an organization, quite a large one, and as you can see, we just did a crack of their password files, and the majority of the personnel actually had password 01, the client's name, password 2, password 06, or the month that they used as their password. We had up to 765 accounts that was actually using password 01 as the password. So if you have a situation like that, it is very, very simple for the perpetrators to do brute force attacks against the password or password guessing to gain access to that environment. This is a second example, also just a smaller organization. Again, 199 accounts where the company name 123 was utilized. The hackers do have password builders. They make use of dictionary type of attacks, brute force attacks where they commit these. And what we've seen is that also some of the statistics are showing that about 90% of all people are using the same password everywhere. So if I send you a phishing mail and I ask you to partake in a competition, I love mountain biking. So if you send me a mail and you say I can win a new Canadian type of mountain bike, chances are really good that I'm going to open that link. And if I have to register an account, I will give my email address as the username, and my password will always be my password. So by just doing that, the criminals then have your mail account and a 90% chance that the password that you've entered there is actually the password for your mail account. That way they can utilize that to gain access to your mail or gain access to the organization's environment. This report from Dimension Data, a South African firm, basically shows that the number of known exploits or known vulnerabilities on operating systems are steadily increasing. So from 2016, we grew from 6,500 more or less to 2018, where we're sitting on 16,500 known vulnerabilities. The biggest problem is that the same report also shows that companies and organizations takes on average 195 days to patch those known vulnerabilities. So that's a huge opportunity for a criminal. All they need to do is literally scan the environment from the outside, identify what type of firewall you're using, do a little bit of research on what's the known vulnerabilities on that firewall, and Bob's your uncle, they gain access to that account by exploiting that vulnerabilities. And we are seeing that in 80% of all the incidents, that is actually the way in which they gain access to the environment. So what we advise people in any place in the world is, if you are planning and preparing your IT security, your preparation should be from the point that it's not a situation of if they do hack you one day, what will you do? But rather to say, when they hack us, what will we do? And that's the level of preparation. I can vouch for that is the situation any place in the world. So we do advise people to follow all the routes in terms of their IT security, do penetration testing, be able to monitor the environment, be able to detect if there's alerts, that you can actually respond to it. You know, if you can pick up a hacker within the first couple of hours or days that he's in the environment, you can actually prevent a lot more damage later on. So think it over, train it in, live it out, because it's your personnel that is going to be responsible for it. Awareness between people, it's one of the most simplest things to talk a person out of their security. I always laugh. My mother is it's an older lady. They stay in a farm in the rural areas, and she would periodically phone me and say, you know, this bank has phoned me and they want to get my password and my details and stuff, but you told me I'm not supposed to give it out. And then I would say, Mum, but last time you told me you're not banking with that specific bank, you know, so it must be a scam. Oh yeah, she also thought about that. But first they check before they do anything. Then in terms of what we've seen, what's the simple, most successful preventative measures? Password management. As you've seen, the companies that we do help with these incidents is not looking after their passwords, don't have secure passwords. Segregation of networks, authorization levels. So you've got a situation where a person is authorized to access anything. So if his account is compromised, the hackers don't even need to go and escalate these authorization levels before they can compromise. It's there from the start. Testing offline backups or tested offline backups. We need to prepare that if the hackers do gain access to environments and they are able to encrypt the environment, that we can lessen the damage. And I want to say in 80% of the cases, the client either left their backups connected, they've got an external drive that they plug in, or they just simply don't have an air gap between their data backup center or their live environment. Dual factor authentication, no person should have any application, any access to their mail accounts without dual factor authentication. And wherever you can have dual factor authentication with your bank accounts, have it activated. As I showed you, patch management versus outdated software. The operating system suppliers is not upgrading the software anymore. If you've got any redundant software in your environment, that is the biggest hole for criminals to exploit. So spend the money and update your software, and then also have up-to-date antivirus. A lot of people think that if they download something that's free of charge from the internet, that it's the best thing that they can do. Actually, you're just getting the cheapest solution out there. And it's free, so there's no commitment, there's no support for it. Go and spend some money on something good. I think security, we had the joke here in South Africa that security is a lot like two guys walking through the Kruger National Park and a lion jumps out, and the one guy stops and he puts on his running shoes, and his friend says, you can't outrun a lion. He says, no, I don't need to outrun the lion. I just need to outrun you. And that's what a lot where security comes down to. If your organization is more secure than the organization next to you, you stand a lot better chance in terms of that the criminals will rather focus on a weaker target than going after or focusing on a more secure environment. So that's more or less the aspects, and we are looking forward to assisting you here in our region. Thank you very much, Gareth.
Fantastic, Danny. Thank you very much. That's absolutely brilliant. Really appreciate your comprehensive overview as well. So many questions coming through, and those received by email have also been forwarded on. Rosalind, you've been very busy giving written responses as well right now in the Q&A. So I'd like to direct anyone who'd like to take a look at some of those Q&As. We'll also provide all of this to everyone after the event, along with contact details. Rosalind, if I may put a question to you that was not on the chat. You've mentioned around the software tax that the opportunity for public comment has not yet even opened. Typically, it's a general question. Where do public inputs come in, and what aspect of a bill like this do you think could see, or a proposed bill could see, further amendment as it goes through the process? Because it is very preliminary at the moment.
Absolutely, Gareth. So, full disclosure, tax is not my first love, but I have been informed by our head of tax on good authority. So the fact is, it's actually not even a bill. It is an idea that has been floated in a paper, and is being considered. Look, I think any way to get more tax is going to be attractive to our government, particularly in times where we need to gather revenue wherever we can. So certainly we see tax legislation does move through a bit faster than other legislation. But absolutely, we have a very transparent process in terms of commenting on bills that are presented to Parliament. There's a public comment process. It's published in the Government Gazette. There usually are a couple of rounds of comments. And I would absolutely encourage the business chamber and any individuals to actively comment on that process. I'm not saying that they're going to agree with you, but it's definitely worth doing and get your voice heard, because it's too late once it's already in.
Great. Danny, I know you're having a look at the chat, and while you gather your thoughts in response to some of those questions, I'm going to come back to you just on another question, Rosalind, and that is around you noted widespread enforcement powers. And the question is, to what extent the legislation is typically giving ministers the ability to add regulations without going back to Parliament. So if I could rephrase, are we seeing a general trend towards anticipating new measures being done by ministerial decree versus that timeline of going through the parliamentary process? Any thoughts there?
So certainly we have a very strong forgotten the correct term now, separation of powers under our constitution. So there's a very rigorous process for any act or any regulations to come into force. Now, it depends on the particular law. It will prescribe whether it's the minister that sets out the regulations or the regulator, but there will always be a comment process. And certainly, our ministers our regulators are all independent constitutional bodies with lots of checks and balances in place. So even if a particular minister is very unhappy about a decision, it will still be done fairly and independently with respect to the rule of law.
Excellent. And better you say that than me, but I was once upon a time elected to Parliament back in South Africa, and I can certainly vouch for that. Danny, coming in, there are a number of questions that you can see on the chat. I wanted to, if I may, draw your attention to issues around insuring against cyber attacks and litigation as a result of cyber attacks. So if you would like to tackle that as part of your response to any of the existing Q&As, feel free.
Thank you very much. Like a good lawyer, which I'm not, I'll start off with a disclaimer. I'm not a lawyer, also not a tax expert, but the cyber insurance in South Africa, basically, the indication is that they can't insure you against fines or regulatory requirements. They can assist in terms of giving you support, giving you incident response in that period, appointing lawyers for you, appointing a PR company to handle the situation for you. But if, for example, you are fined for specific transgression, or you are required to pay a certain penalty, the insurance doesn't kick in for that. Ross, I don't know, you might also have some background in that area.
So I'll just add, I mean, I did in the chat say it's absolutely critical. I must tell you, we've been involved in a number of matters where people have thought that they had cyber insurance, but instead had a cyber fraud policy or something that didn't cover them, and it's devastated their business. One of the questions that's come up is, what are the costs of a cyber breach, other than you see in the press? I must tell you that, even without the penalties, the costs that are associated, reputational first and foremost, is really significant, particularly if you're a consumer-facing organization. Making sure that people feel like your data is secure is top priority. The cost associated, I mean, Danny will know better than me, and the forensics of actually, it can take many months to actually remove the threat actors from your environment. the business interruption, the restoration costs are really just hugely significant. So whatever, support you can get from an insurance perspective, would highly recommend it. The other thing I want to say, particularly on cyber responses, is that, the success of an incident response is how well the organization is prepared for it. Danny and I both sit on the same panels for some insurers and help people respond. And the challenge we have most often is that people don't know who the decision maker is. They don't know if it's the IT team or the head of the board and you have to move so fast in these situations. You've got to be so responsive. So it's absolutely critical. Have your incident response plan tested. And even, if you can afford it, do penetration testing on a regular basis. Do, a fake incident just to see if you're prepared, because it really can save a lot of trouble in the long run. In doing that. And just to touch on Danny's point, which is a really key one, is generally in South Africa, the rule is that insurance will not cover you against your own intentional or fraudulent conduct. So that's why if you do get a penalty, it's not usually going to be covered by an insurance policy.
Excellent. And for anyone who's ever been to the Canada Pavilion during AfricaCom, you'll know so many of the Canadian companies here operate across the continent. So if I may, though this is a South African panel, I do have a question just around trends in the rest of SADC. Rosalind, have you picked up that other countries across the continent may sometimes respond to legislation in South Africa, or that South Africa is actually following the lead on how to legislate in other parts of the continent or the world, just in terms of that general trend, if you have any observations? And then Danny, also a trend question, some of the risks you identify for South Africa, how do you see that playing out on the rest of the continent? So any thoughts you have there, particularly with a focus on SADC markets? Rosalind, I'll kick off with you.
Sure. So Gareth, actually, because of the global world in which we live and the way data goes, we often see incidences affecting hundreds of countries at the same time. So we regularly engage with companies or with law firms and responders all over the African continent to deal with it. The South African, the information regulator, is very involved in the African Union and is driving data privacy as a real focus across the continent. There are many countries that don't yet have data privacy laws in place or cyber laws, but where it's definitely increasing at a rapid rate. And we certainly are seeing a lot more sort of collaboration and follow on. Typically what we see is that South Africa provides a lot of support to other African countries in terms of training regulators, helping them to learn how to respond, learning from best practice, because we tend to deal with it first and then move it along. But it definitely, there's a rapid focus throughout the continent, and everyone is alive to the necessity to protect data.
Brilliant. Thanks a lot. Danny.
I think the one thing that we can say about criminals is that, they're not lazy. The other thing is they adapt very easily. What we're seeing is that the same syndicates are involved in a number of different type of attacks. So you'll have a syndicate that operates across Africa. In one area, they'll focus on, smuggling of iron, of ivory or rhino horns, those type of things. But the same syndicate will also be involved in human trafficking, drug smuggling, those type of things. And the same applies in the cyber syndicates. So where South Africa is more developed, we are starting to see that our syndicates that's attacking us is following the same trends as what is happening in Europe, the same type of attacks. It flows over the borders. And they might see African countries as being lacking behind in security. I myself know that I have traveled to a number of South African or African countries where security is not getting the right type or level of attention. We're also sitting with a situation where There's mergers and acquisitions happening with organizations. You're buying a firm that's got offices in Kenya or Nigeria, etc. But their level of security is not necessarily where the rest of the organization is. And that becomes a very weak point. So in South Africa, they may have a lot more sophisticated attack. But in Ghana or Botswana or Nigeria, for example, they might do something simpler like credit card skimming, working their way up. They really don't mind adapting as long as they're getting paid for their efforts. And they do basically focus on any type of attack.
Thank you, Danny. A quick question, if I may ask you, Rosalind. I know you're responding to Sabelo Sibanda's question, but I think, you know, the general point around the return on investment for mitigating against these risks is a very good one. And I wouldn't mind if you would share your thoughts on that with the group as a whole. And then, Danny, a question to you received in French. So if need be, I'll just do a quick translation. And that is, my French, forgive me if the translation in any way is inaccurate. But really, when you're going to your point around multiple different markets, you know, you have different types of websites, different styles. Generally, what do you use when one receives a business inquiry from a given website? What are some of the flags that you use to check if indeed this is legitimate or not? Because sometimes a small business may have a website that might not be as sophisticated as a major corporate's, but, you know, it is legitimate. And at other times, you know, that's not the case. Just generally, any pointers that you use to distinguish between what's authentic and what's not, for people to do that really quickly in real time. Rosalind, I'll hand over to you for Sabelo's question.
Oh, hang on. So, yeah, so Sabelo, about the return on investment. So this is a really, I mean, it's a really tricky thing. The fact is that I don't think you have a choice anymore. You know, we're moving into such a digital world. If you don't use data, if you don't participate in a digital economy, you're going to get left behind. So in terms of return on investment, you know, it's like any regulatory risk. I think, you know, I flippantly said you spend $1 on compliance, you save 4 along the line. I cannot overestimate the importance of making sure that the organization's information policies, you know, whether it's personal information or security of data, is absolutely top of mind of the board, and making sure that there are measures implemented, because it is going to save you money in the long run. Because the regulatory investigations as well, people don't realize they take a long time. They take a lot of effort. They take a lot of management time, and there are costs there as well. But I don't think you can say, oh, well, the cost of data privacy compliance or the risk of a data breach is too large for me to even get involved in a digital market, because you know, certainly in my opinion, if you don't have a digital presence in the next 5 years, I think you're really going to struggle to reach a broader market. So in offsetting it, it's you know, lawyers are typically risk averse, but I would say make sure that you do what you need to do up front to make sure that you're compliant. Make sure you train people regularly. That is, I cannot tell you enough. It's the one person who clicks on the phishing mail. It's the one person who's feeling economically vulnerable that exposes the whole organization. And there are ways that you can mitigate that risk so that you do make your proper investment. But yeah, so it's hard to put on a figure on it. And I would say upfront investment, it will pay off in dividends in the long run.
Fantastic.
If I can, you know, just tag on to that. You know, I totally agree. You can't look at return on investment in terms of something like cyber insurance. We typically tell people you've got a couple of things to focus on IT security. Number one, you want to prevent it. If you can prevent it, that's the best situation. Number two, you must be able to detect it. If there's a breach, you must be able to detect it. Number three, you must be able to respond to that breach. And number four, you need to recover from it. Now, if we tell each other, listen, it's a known fact that big banks are being hacked, big IT organizations internationally, small, medium firms in Africa is definitely also going to be compromised, any firm, anywhere. So the only way in which you can recover is if you've got the insurance. So we're spending 80% of our budget on that prevention and detection, but spend 20% on the recovery as well, because we're preparing for, if it goes wrong, that we do it. In terms of verifying people online, very, very difficult. The criminals in the olden days, we had scams where, in the olden days, that was 10 years ago, more or less. It could be a couple of months ago sometimes. But we would see that some of the syndicates was, for example, from the East Bloc countries, where you could see the spelling wasn't very good. They'll send you a mail and there was spelling mistakes and grammar mistakes, etc. These guys have become very sophisticated. They do build profiles. They do it for a living. They are in a syndicate where they are maybe not rewarded by money, but by brute force to perform well. So we see that the scams are elaborate. But for example, if you're dealing with an online entity, number one, look at the address, look at the telephone numbers, do independent searches of it. If a person sends you an invoice and you want to validate the banking detail, don't phone the telephone number on that invoice, or don't phone the telephone number on their website. That's how they catch you. So try to go to a business directory and get their details from there. Also have a look at whether that same address is being used at different locations. Google Earth is an excellent way in terms of visiting that site. Have a look at the people that works there. Go and check out, LinkedIn sites or Facebook sites, or do a collaborative scan on the environment. And then also do your due diligence in terms of, if you're just ordering something across line or online, go and check at reported scam sites. Is there any complaints about this organization? Those type of things can help you. And then never transfer money unless you've confirmed it. We've got scams running where an organization will look at who's the service providers to government here in South Africa. They will then contact those service providers and say, I'm phoning you from the department of so-and-so. You are a service provider with us. We want to order 1 million of the following item. And they give you the reference number. They say, listen, it's not on their procurement list, but please, if you can supply it, they want to buy 1 million. And they make it so enticing. And if you start Googling and see where you can buy to sell it to them, there's only one place where it's sold. So that's the scam. You then go to their site, you pay over a couple of $1 million to buy the items, and then it's never delivered, and that's the scam. So never ever believe anything that is mailed to you, that's sent to you. Try to validate everything.
And for anybody who does have any questions on the legitimacy of a particular company or its background, the Trade Commissioner Service does offer fantastic insights and is able to assist with any queries in that regard, specifically when it comes to orders. I know many of our Canadian companies have had great experiences just double checking and having that peace of mind. One more question, and this is going to be to you, Rosalind, and it's a closing question because we have reached the end of our time. And I am going to invite Mike Morgan of the Southern Africa Canada Chamber of Commerce to say a few remarks as we conclude. But Rosalind, a very specific question around the distinction between private and organizational breach of privacy. Quite simply, if somebody is using a server or an email address of a company and there is a breach that arises, is that company automatically liable, and then does it fall to the company to discipline the employee? And how do companies, do they need to put policies in place to demonstrate that they have mitigated to the best extent possible against a breach? So I know it's actually a bit of a packed question, but any insights would be great.
Okay, leaving the hard one for the finish up. So look, the fact is you have to look at who the responsible party is. So if that employee is processing information in the context of their job, and as they are supposed to, then, and they don't follow the policy, the company is still going to be liable for any harm caused to someone, but they might be able to mitigate a penalty. They said, well, we put in all the measures in place, they didn't follow instructions, or we had a rogue employee. But the fact is, if they're doing it in the course and scope of their employment, the responsible party is going to be responsible. In terms of sort of private behavior, I mean, it is important to note that POPI has an exclusion in the sense that it doesn't apply to something that's done in a purely personal or household process. So it only really applies to personal information that is processed by, public or private entities in the course and scope of their business. But absolutely, I can tell you that when you report a data breach, one of the questions on many of the forms is, when last did this employee receive training? And so that is the thing, is it's your responsibility to make sure that people are aware of their obligations. And I would highly recommend that you have very clear policies so that you can easily take disciplinary action. Regulators look very dimly upon companies who get in trouble because of things that their employees do, and then they don't actually take disciplinary action. So it really is, it has to be, privacy has to be part of the culture of the organization in order for it to be effectively managed.
Rosalind, thank you so much. Danny, thank you too. These insights have been absolutely fantastic. And to each of you who are with us, there will be a follow-up email, and you'll see my email address in the chat in just a moment. But feel free to respond to any correspondence you've had with me so far, and we'll certainly facilitate an answer to those questions. I am very pleased at this particular point to recognize an individual who has been a key part of all the Chamber's operations in South Africa, and that's a partner to our Chamber here in Toronto, and that is Mr. Mike Morgan. Mike is the leader of the Southern Africa Canada Chamber of Commerce, a key partner in events like these. And I just wanted to offer a few words as we round off to you, Mike, and say thank you very much for your support and a wonderful relationship between Canada and Southern Africa.
Gareth, thank you so much, and good morning to our Canadian friends, and good evening to all those on the South African continent. It's been great participating, and once again, Gareth, I'd like to acknowledge you for your support in upholding the spirit of our MOU, which we signed, as you mentioned earlier, down in Cape Town with Minister Mary Ng, way back, it seems like an age ago, in February 2019. I'd also like to just take this opportunity to acknowledge the wonderful support and collaboration we enjoy with the High Commissioner of Canada Trade Commissioner Services, to Marcello and his team, and to you, Your Excellency, the support that you've already shown us. We look forward to taking these initiatives forward. So to Ros and to you, Danny, thank you so much for your time. To all our local second chair members who have participated tonight, thank you, and we look forward to hosting you on future events like this. Gareth, thank you so much. So from South Africa, goodbye.
Thank you very much. And really, you've said it all. And I really appreciate that wrap up, and look forward to the time where we can be together again, back to that period of cooperation on the ground that we had both in Canada. But this has been fantastic. Thank you once again to His Excellency Chris Kuta, to Marcello DeFranco, to the entire team, Nina Dube, who leads on ICT, Michael Shapiro, and everyone who's involved in making events like these happen. I challenge any Canadian company who has any question. I doubt you will be left without an answer within 48 hours the moment you approach the Trade Commissioner Service. If you're not in touch with them as yet, please let me know, and I'll make sure that that contact is facilitated. Have a wonderful rest of the evening to all of those in South Africa, and to everyone else here in Canada, a happy good morning in Vancouver, and a good rest of the afternoon in Ontario and across Quebec and the other provinces. Thank you so much. Bye-bye.
Bye all.